I'm Alicia Hurley. I'm the acting director of the John Brademas Center for the Study of Congress. I'd like to recognize former Congressman John Brademas, who's here with us today. He was also the president of this university for 10 years and really set us on the trajectory that we find ourselves today. So for those of you who have joined us in the past, we've been doing this program annually since 2005. Constitution Day is actually now mandated across the country for anybody who gets any federal research dollars or student aid dollars, that you must do some programming to celebrate the Constitution. We've always been very happy to do it. We find it very interesting part of what we get to learn every year. And I find this year will be a particularly enlightening conversation. I just got to listen to these two gentlemen for the last 5 minutes, having quite an exchange in the back. So we promise you a very good program. So let me start off with Congressman Jerry Nadler. He represents the 8th Congressional District of New York, which includes the New York University campus. He began his political career in 1976 in the New York State Assembly and then was elected in 1992. He is the chair of the Judiciary Subcommittee on the Constitution, Civil Rights, and Civil Liberties. So I think we can.
Ranking member now.
Yeah, forget that. Should only be the chair.
That's right. So ranking member, but as you can tell, we have probably one of the best legal minds here from the Congress to talk to us today. He is joined by our own Professor Burt Neuborne. Professor Neuborne is the Inez Milholland Professor of Civil Liberties and founding legal director of the Brennan Center for Justice at the NYU Law School. For 45 years, he has been one of the nation's foremost civil liberties lawyers. He was the National Legal Director for the ACLU, Special Counsel for the now Legal Defense and Education Fund, and New York City Human Rights Commission up until 1992. So let me turn it over to them. We have just under an hour. Both have to leave at 1:30 promptly. So they're going to talk for a bit, and then we're going to open it up for questions at the end. Thank you very much.
Thank you, Alicia, and a special thank you and a special honor to have John Brademas in the audience. When John was the president of NYU, I was a junior faculty member, and it was wonderful to have leadership like that. Thank you, John. I should start by saying that this entire day is unconstitutional. Congress doesn't have the power to say to every school that gets money from the federal government that it has to have a compulsory program to study the Constitution. That's what the Constitution was designed to prevent, the government telling you what to think and what to study. Now, having said that, I'm not going to challenge the constitutionality of it. One, because I value my job, and two, because Senator Byrd was right in 2007 when he sponsored the legislation providing for Constitution Day, albeit I wish it were voluntary, because the notion of having a day set aside to think about the Constitution is altogether correct. We celebrate, we should, I think, and Senator Byrd thought we should, have 3 great national holidays. July 4th to celebrate the courage and wisdom of the founders in founding the nation back in 1776. Memorial Day to celebrate the extraordinary bravery of generations of Americans who've given their lives so that we can continue to live in freedom. And Constitution Day, which Senator Byrd thought of as a day celebrated consecrated to thinking about what it means to live under the rule of law and under the rule of a constitution. The American Constitution celebrates its 222nd birthday. It is the longest running charter of democratic governance in the history of the world. No charter of democratic governance has lasted even half as long. So we have a good deal to be grateful for and to be thankful for. Although at this point, it's right for me to stop for a moment and recall a speech that Thurgood Marshall gave in celebration of the 200th birthday of the Constitution. Marshall said the Constitution was a wonderful thing, but it was not a perfect document. And we shouldn't think it's a perfect document, and we shouldn't think the people who created it were angels. There are two very serious problems, gaps, in the original Constitution. First, its dalliance with slavery. There are provisions of the Constitution that nobody in this audience today wants to read. The provision that said that black slaves in the South were to be counted as 3/5 of a human being for the purposes of representation. The provisions in the Importation Clause that said that the Constitution forbade limits on the importation of slaves until 1808. And finally, the infamous fugitive slave law that said that if a slave escaped from the South and was able to reach the North, that the Northern authorities had a duty to capture the slave and send the slave back to the South for punishment. But at least we can say that the dalliance with slavery was corrected. The 13th, 14th, and 15th Amendments in 1868 and 1870 eliminate the taint of slavery from the Constitution. And so while we should recognize that it wasn't perfect in the inception, we should also recognize that the Civil War and the sacrifices of the Civil War led to the purging documents, the 13th, 14th, and 15th Amendments, of which we should also be extraordinarily proud and remember now that they are part of the beating heart of the Constitution, not just amendments. They are at the center of what the Constitution means, because they brought equality into the Constitution for the first time. And then the second problem with the Constitution is it had no Bill of Rights. And that wasn't fixed until 1791, when we finally tacked the Bill of Rights, when Madison tacked the Bill of Rights onto the end of the Constitution. So in celebrating the Constitution, let's celebrate both our good fortune in being able to correct it over time and celebrate the fundamentally extraordinary nature of the document itself. So I think the Constitution has three values for us. When I was thinking about why I care so much about it, it has three values for it. It has a symbolic value, it has an aspirational value, and it has a political value. Now, the symbolic value of the Constitution in a democratic nation like this, without kings and queens and nobles and white horses and all of the panoply of government that goes on in monarchies and governing systems with a different sense of where power comes from. The Constitution is essentially the thing that binds us together symbolically in a single nation. It is the concept that everybody from the far left to the far right can unite to defend and say that it's ours, that we're proud of it, that we live under it, and that it symbolizes the unity of a free people attempting to govern itself. And we should remember, and we should reinforce the symbolic nature of the Constitution on Constitution Day. But it also has an aspirational value. The Constitution is a kind of prophetic document that calls people to be better than they have been. It lays out values of enduring human dignity, values like free speech, freedom of religion, limited government, autonomy, equality, procedural regularity, values that we aspire to most of the time, but fail to be able to achieve in our political life. And so we should recall that the Constitution is not only hard law, it is soft law in the way that the Sermon on the Mount is soft law, and that it calls us to be better than we are. And in the long run, the symbolic nature of the Constitution and the aspirational nature of the Constitution may be the two most important ideas that resonate in American life and that provide us with the hopes of building a truly decent society. And then there's the third piece of the Constitution, the piece that I want to talk just a little bit more about today. That's the political aspect of the Constitution, because the Constitution was a genuinely revolutionary document when it was adopted. Up until the adoption of the Constitution, every single charter of governance in the history of the world was what I will call a top-down charter, where some superior power, whether it was God or the local gentry or the guy with the biggest army or the person with the most money, was giving government down to the people that were to be under the control of the new government. It was a top-down government where power flowed from the rich and powerful down to the weak and governed, and only as much power as the rich and powerful were prepared to let trickle down were exercised by the lowest rungs of society. The American Constitution turns that on its head historically and creates an entire new conception of governance in the world. It's a bottom-up conception of governance, where the people are the repository of the power, and they delegate that power upwards to the people who are temporarily placed in a position of governance to exercise it through democratic choice and reasoned selection. It is the first bottom-up document granting power in the history of the world. And as such, it is an enormously important historical episode in the development of governance in our society, in our world. And today, the notion of the bottom-up as opposed to the top-down is the system of governance that operates throughout the world. Now, having said that, what does that mean? Because that's what makes it interesting today. Today, we are living through a debate on what that delegation was really all about. Up until very recently, the usual wisdom was that what had happened was the people had delegated to the governing groups a power pursuant to a flexible document, the Constitution, that was capable of being read in different ways at different times in order to deal with changing society, so that no one thought that the First Amendment would mean the same thing in peacetime as it meant in wartime, or that the various clauses designed to deal with a small agrarian republic where the single largest city had less than 25,000 people, which is what was in fact the case in 1789. Philadelphia had just under 25,000 people, and it was the largest city in America. A document designed to govern that society, an agrarian society with just the beginnings of an urban population, would mean exactly the same thing. In today's world, in 2011, where you have this unbelievably intense and complex urban-dominated society that requires forms of governance that the founders never even imagined. And so the one way of thinking of the Constitution is as a flexible document with core meanings that can never be changed, but with a series of peripheral meanings that change in accordance with the times, so that the document expands and contracts in ways that make it useful and dominant in periods of different cultural, social, and economic change. That's what Brennan used to call the living Constitution, a Constitution that evolved with the times. Now, the counter view of the Constitution is the Constitution has a single fixed meaning that was locked into place on the day it was adopted in 1789, and the Amendment Bill of Rights in 1791, and the later amendments on each day. And that is a fixed and unmovable set of meanings that can be changed only through amendment. Now, in recent years, that idea, which had been fundamentally rejected by generations of American constitutional scholars, has come closer and closer to being the reality. It is the mantra of the Tea Party. It is the mantra of conservative theoreticians who argue that the Constitution is not a flexible document. The Constitution is a straitjacket. that places the government in a kind of fixed set of activities which can never vary, no matter how much change takes place in the society. The right to bear arms is the classic example of the argument there. They took the Second Amendment, which dealt with muskets that were needed for militia service in 1789, and turned it into a device to be able to carry repeating revolvers in courthouses, in schools, and all over the country. And they did it through saying it had a fixed meaning. That fixed meaning in 1789 or 1791, when it was adopted, is the fixed meaning that we have now. Now, the difficulty with that is obviously no constitution will last 222 years. We will not be here 222 years from now celebrating the American Constitution if it is a fixed document that can't change. It will crack. It will split. Times will change. The document will be unable to change with it, and it will be discarded as the constitutions of the Republic of France, the first, second, third, fourth, and fifth, were all discarded because they couldn't change. So that in order to preserve the Constitution, I think one has to reject this notion of it having a single meaning. And then the final thing I want to say before I turn it over to Congressman Nadler is the notion that the Constitution has a fixed meaning presupposes the fact that someone knows what that fixed meaning is. That you're able to take the document and read it, and just by reading it know that it has a single meaning. Well, no document that lasts 222 years is drafted with that kind of specificity. By definition, it is general. What does due process of law mean? What does the freedom of speech mean? What does cruel and unusual mean? What does regulation of commerce among the several states mean? It doesn't have a literal meaning. No matter how hard you try to read it literally, it resists literal meaning because the words are too broad. Notions of originalism is what the right are trying to use now. And they claim that what we do is go back and figure out either what the person who wrote it meant, or the person who ratified it meant, or the person who members of the general public meant. They keep shifting back and forth. There are three theories of originalism: ratifying the drafting originalism, ratifying originalism, or general public originalism. And they move them around like shells in a shell game to get the meaning they finally want. But even then, when you look at historical evidence, the meaning of the Constitution is almost never fixed. It is, when you look back to the founding generation, you see that they were as divided as we are about important issues. Intelligent people are never monolithic. And so the notion that you can go back and find a fixed meaning and import it all across the time today seems to me to be clearly wrong. And yet, that is the idea that is dominating constitutional jurisprudence today, this notion that somehow we are engaged in a historical search for an empirically discovered objective meaning. And sadly, it just doesn't exist. And the important thing about meetings like this is that now that you have your own copy of the Constitution, and I hope you will carry it with you as I carry mine, when you have your own copy of the Constitution, read it. See if you think there's a single fixed meaning there. See if you think that the document doesn't cry out for someone saying, this is a flexible document. This is a living Constitution. This is a document that has our values, our hopes, and our aspirations built into it, but it is not a straitjacket. Thank you.
Thank you very much. It's a very great pleasure to be here, and thank you for the invitation. And I'm here just a bit too late because my son just graduated from the law school, so he's no longer here. In the last, and starts at Paul Weiss today, so I'll have to see how he does tonight. In the last 2 years, and especially in the last few years, especially in the last 2 years, the Constitution has increasingly become the subject of a great deal of discussion and debate in Congress. It's always been the subject of a great deal of discussion and debate outside, but now inside. Regrettably, it's falling victim to the old definition of classical literature as books that are often praised, but seldom read. In Congress and in the media, however, it's often read, but even more often ignored or given novel and unsupported interpretations. The Constitution has become less a template for a Republican form of government, with a small r, and more a Rorschach test for political ideology in the last year. To some extent, this is hardly a new phenomenon. The Constitution's use of general terms does provide us with the ability to apply important principles to society as it develops. And that's always been the case, as Professor Neuborne mentioned. And by the way, even among the first generation, you had the Federalists and the Anti-Federalists. They differed initially as to whether the Constitution ought to be ratified, but they differed after that as to what the Constitution that they had participated in writing meant. And that was the foundation of our first political parties, a split in constitutional interpretation of a then very contemporaneously written document. And much of our jurisprudence, constitutional jurisprudence, has to trace to some of the great decisions, McCulloch versus Maryland, Marbury versus Madison, written at a time when on the Supreme Court were people who had participated in one way or another, were part of that founding generation, and were part of the debates as to what the Constitution meant as they wrote it. The Constitution, but the general language of the Constitution can also present an opportunity for different ideas of how it should be applied to something bordering on free association. From that, there have been some peculiar developments in recent times. On the first day of the new Congress this year, the new Republican majority organized a reading of the entire Constitution on the floor of the House of Representatives. This was intended to be a demonstration of the importance of the Constitution and our fealty to its text, as if the previous Congress had ignored it. That's the good news. As the former chairman of the Subcommittee on the Constitution, Civil Rights and Civil Liberties, and now as the ranking minority member of the newly renamed Subcommittee on the Constitution, because the Republicans didn't want to keep civil rights and civil liberties in the name of the subcommittee, I was happy to participate. Surprisingly, they decided to read a Bowdlerized version of the Constitution that omitted such uncomfortable language as the 3/5 clause. Now, that is thankfully no longer a part of the Constitution, but it is part of our history. It's also an illustration of what the American experiment is at its best, a constant struggle to live up to the fine words of our founding rhetoric. The men, and they were all men, who crafted the Constitution had among their number a goodly number of slave owners. But that was not the end of the story. We rose above that history and above the history of the exclusion of women and a variety of other shortcomings to reach the society we have today. The lesson is that we are capable of moving forward. It's a lesson of the past and a mandate for the future. Now, the current new majority in the Congress has, from my point of view, a very cramped view of what the Constitution means. That's illustrated by removal of the words civil rights and civil liberties from the title of our subcommittee. But they have also a cramped view of the powers of the federal government, which is partly conditioned by the new majority's anti-government philosophy, and partly by a view of federalism more reminiscent of John C. Calhoun than of the current era. Rallying cries not heard since the segregationist revolt of 50 years ago are now common. So how does this play out? We have members of Congress, and for that matter presidential candidates, who believe that the Social Security system or the interstate highway system or health insurance are unconstitutional. We have members who believe that the application of civil rights laws to state governments is unconstitutional. As this concept is unfortunately now reflected in certain decisions of the current Supreme Court, it perhaps should not be viewed as a fringe idea. We even had a member a few years ago of the House Judiciary Committee who used to say at committee hearings that the Supreme Court had no authority to invalidate acts of Congress and that Marbury versus Madison was wrongly decided. Another member who still sits on the committee complained that when he attended a session of the Supreme Court, he heard no discussion about the Constitution, quote, just a lot of cases, unquote. I don't know what he expected to hear at a court session. Now, there's a bit of hypocrisy on all sides of the debate on the Constitution. Those who railed against activist judges for striking anti-same-sex marriage laws cheered decisions that struck down gun control laws and campaign finance laws. Other members denounced and cheered those same decisions for opposite reasons. Similarly, we have the long-standing debate about the existence of unenumerated rights as outlined in Griswold versus Connecticut. Many on the right bristle. You remember the Griswold was the case that declared the Connecticut law against contraception unconstitutional because it violated the right of privacy, which the court discovered in the penumbras and emanations of other parts of the Constitution and the Ninth Amendment. And many on the right bristle at finding such an unenumerated right in the Constitution. Yet many of those people, but many of the same people support Pierce versus Society of Sisters, the 1925 case, which enshrined, quote, the liberty of parents and guardians to direct the upbringing and education of children under their control. That was the case under which, in the hysteria of World War I, it was decreed that private schools, it was decreed by Congress that private schools couldn't teach in German, or couldn't teach German, and some German Americans who had such private schools brought the case. And I think the Supreme Court rightly decided that they had the right to continue doing that. These people who object today to the finding of rights unenumerated in the Constitution forget what one of the major objections to the Bill of Rights was. When at the ratifying conventions, the absence of a Bill of Rights was objected to, the answer to that was, the answer did not prevail. We did adopt the Bill of Rights, and that was a condition that some of the ratifying conventions put on adoption of ratifying the Constitution, that we would adopt the Bill of Rights, which the subsequent First Congress did propose to the states. But what was the defense against the absence of a Bill of Rights? Number one, we don't need it, because it's a government of limited powers, and a government of limited powers will find it difficult to violate those personal rights. It's lucky that that view didn't prevail. But secondly, we must not have a Bill of Rights because a Bill of Rights is dangerous. Why? Because no matter how many rights you think of, there will be rights you don't think of and don't put in. And a Bill of Rights that says you have the right to do this and the right to do that, but omits the right to do the other thing, will be construed to say you don't have the right to do the other thing. The unenumerated rights would be construed not to exist. And that was an objection. And to some extent, it was a valid objection. And that's why we have the 9th and 10th Amendments that say that the rights that aren't enumerated shall not be construed, that they don't exist. And yet, a strain in American history is if it's not there, it doesn't exist. Perhaps it would be a good jumping off point for our discussion. How should we think about the Constitution, and how should we read it in a rational and coherent manner so that it serves as a guide to the work of the Congress? By raising these questions about the Constitution, even if their answers can sound absurd, the Tea Party may actually have performed a useful service, which would probably be their only useful service.
A show of hands of who has questions in the audience. I want to try to gauge how to spend the next 25 minutes or so. We have a number. Don't make us call on you. Don't make us call on you. Why don't we go ahead and start the questions, and I'm sure that will be very helpful. Go ahead and please do use the microphones on the sides.
If you talk up, we'll hear you.
I can talk really loudly. First of all, thank you very much for being here. I was curious, you talked about this bottom-up kind of form of government, and I'm wondering your thoughts on campaign finance, because it seems that, you know, especially in the last couple of decades, we've had a lot of really wealthy candidates. So I'm curious, we talk about the people having kind of the power over selecting their representatives, particularly presidential candidates, but so much money seems to be required in order to make it to that point. How do we reconcile that?
That's a great question. For those of you who might not have heard it all, it was really, how does our current campaign financing laws and the Supreme Court's response to the campaign financing problem, how can I place that within an intellectual world where I've said the government is bottom up? Isn't that top down? I mean, isn't that rich people telling the rest of us what to do instead of ordinary people having real power? Is that, so the answer to that is, once upon a time, I was very smart. once upon a time, I was really thought of as a very smart guy. And then I lost my 5th vote on the Supreme Court, at which point I got very stupid. The truth is the Supreme Court has shifted, and shifted on campaign finance cases, in large part, I think, in a extraordinarily both anti-democratic and very, very wrong as a matter of First Amendment doctrine. Under existing campaign finance laws, for example, corporations, as you may have read in the papers, corporations, big profit-making corporations, Exxon, Chevron, the major corporations in the country can use as much money as they want from their vast corporate treasuries and pour that into election races in order to elect the candidates of their choice. The only restriction is they can't give it to the candidate. They have to spend it independently of the candidate. Now, when that case came down, I wrote a piece that said, it's astonishing to me that the Supreme Court thinks that corporations are people, that they treat them as though they are living sentient beings with a conscience and a soul. I said, if things keep going this way, you're going to be lucky. Maybe you'll get adopted by a corporation. If you're really lucky, you'll get to marry one. Until then, you just better be prepared to be ruled by them because they have so much power. The single most important political issue in American life today is to fix our campaign finance system so that control of the democratic process doesn't rest with the top 2% of the economic system. We have a 3-tier system of democracy in this country. Super citizens, 2% at the very top, the very rich. They have the disposable wealth in order to fund the process, to make the contributions, to essentially set the agenda. 50% of the population, the rest of us, who vote. Only about half of the population votes. If we get 60%, we think it's been a great election. 2% of the top, they're the super citizens. They provide choices for the rest of us. We accept or reject those choices, but they're not our choices. They're choices that have been made for us by the super rich. And then finally, the bottom tier are spectator citizens. Half of our country doesn't vote, even though they are affected dramatically by this. And it's not because they're dumb, and it's not because they don't want to vote. It's because the system is set up in ways that inhibits them from doing it, makes them register before the election, holds the election on a work day. Why isn't the election on a holiday? So that working people can vote without having to worry about who's going to watch their kids. Why do we have voter registration long in advance of the election? The result of all those things is to essentially weed out the poor from the electorate. So that we have a serious problem. It's fixable, but it's fixable only if we get one more vote on the Supreme Court.
Let me comment on that, if I may also. I've said for a long time that the campaign finance system that we have is a metastasized cancer in American democracy. And if we don't fix it soon, the historians will write of the American Republic as they do of the Roman Republic. We had a nice 200-year run with democracy, and then we evolved into something else, into a plutocracy or an oligarchy, and we're well on the way to doing that. The ability, let me put it this way. When I was in college, when I was a freshman in college, I joined a local Democratic club on the Upper West Side. Whatever you may say about a political club, Republican, Democratic, liberal, conservative, it's an association of people in the neighborhood interested in politics. And as such, it is a gossip society. And the staple of gossip in any political club is, have you heard Jones is thinking of running for whatchamacallit? 40 years ago, the automatic riposte was really who's supporting him or whose support can he get. Today, the riposte is really how much money can he raise, or where's the money coming from? Support in organizations has become totally secondary. Money has become dominant, even at the very local level. And that's poisonous for democracy. The Supreme Court, which held that corporations are people back in, at least for 14th Amendment purposes, back 100 years ago, 130, 40 years ago in 1886, has now taken this to the nth degree. And if you look at our politics and you look at the polls show, for example, that taxing the rich is a very popular thing to do at a heavier level. And yet, it is very difficult to get it done. Why? Because Democrats as well as Republicans have to raise huge amounts of campaign finances. The president is looking at raising $1 billion for his own campaign. Where does that come from? It comes from a very small sliver of society at the top who have a much larger say in what goes on than they should, and now from corporations. And corporations, remember, are given privileges and immunities by law that most of us don't have. And then this new privilege of financing our campaigns. We've got to stop this, and it's very difficult to see how without getting the Supreme Court to change. We can propose constitutional amendments, though I'm very reluctant to amend the First Amendment, but we're not going to pass them. It's almost impossible to pass the constitutional amendment. You know what you need, 2/3 in both houses of Congress, and especially when your proposed amendment deals with the distribution of power, and you've got you get the people elected in the Congress and in the states under that distribution of power to vote to change it, becomes very difficult.
Lest both Congressman Nadler and I sound too pessimistic, the dissent written by Justice Kagan in the most recent campaign finance case, which struck down a very thoughtful Arizona program. I didn't think you could put thoughtful and Arizona together in the same sentence, but a very thoughtful Arizona program that provided for matching funds, saying if you take campaign subsidies and the guy that you're running against is outspending you in a crazy way, we'll give you some more money to meet his out-of-control spending. Supreme Court declared that unconstitutional. They actually said that it is a penalty on a rich person's speech to have that rich person's speech trigger an answer. And I was astonished. The notion that being answered is somehow a penalty for a rich person. And so the Arizona program was struck down as unconstitutional as well. Kagan wrote a brilliant dissent for 4 justices. We're 1 vote shy of being able to fix it. And by the way, the New York system survived. The notion of a energized match, where you match $100 or $200 private contributions with a multiple match, allowing a relatively poor candidate to raise a fair amount of money through subsidies, that's still constitutional.
But you cannot, under that system, in the New York City election, for instance, New York City Council election, you can spend, I think, $150,000 total.
That's right. That's right.
And for contributions under $175, you'll get a 6-to-1 match. But if someone comes along and says, I'm not going to participate in that system, and I'm going to spend $1 million, it is now unconstitutional for the city to say, all right, we'll increase the 6-to-1 match, or we'll increase the spending limit of $150,000, because that's a burden on the guy who wants to spend $1 million.
Well, I'm going to argue that lifting the spending ceiling hasn't yet been decided yet.
Well, I hope you're right. But
because after all, you don't spend 48 years as a civil rights lawyer without running against every brick wall that you can find. I'm going to try to
I hope you're right.
Okay.
I should also add that these cases are one of the few areas where I find myself in disagreement with the ACLU, which takes a very different view on campaign financing.
Well, I should tell you, I was national legal director of the ACLU during the Reagan years, and I've broken with them on this issue. I think they think that the campaign financing regulations violate the First Amendment. I think they've forgotten that the purpose of the First Amendment is to create a vibrant democracy, and the First Amendment now is strangling it, not helping it be a vibrant democracy.
Under the current interpretation.
Yeah, under the current way of reading the First Amendment.
You've both spoken a little bit about the recent turn to a more originalist reading of the Constitution in both the judicial and political arenas. And I was wondering if you both spoke, I think, in a fairly pessimistic way about the potential for where that could lead. And I was wondering what sources you see of potential pushback against that reading in the future, either politically or judicially, if there's sort of a way that people are finding to push back against that interpretation.
Let me say, I don't want to sound so pessimistic on that. Probably the key, or one of the key tests on that now, is the health care law, where, of course, the key question is how expansively you read the Interstate Commerce Clause. Does Congress have the power to do what it did on under the jurisprudence of the Supreme Court since 1937, the answer is yes. And I do think that the odds are that the Supreme Court is still going to say yes, and is going to read that as constitutional. There was a time in the late 90s when the Supreme Court seemed to be going to a very narrow, toward a more narrow reading of the Commerce Clause, maybe even back toward Lochner, but it reversed itself. It didn't take that very far. And I hope, and I do think that it probably won't go that way. If it does, we'll have worse problems, but I don't think that's going to happen.
Yeah, I'm optimistic on that case as well. I should say something about originalism. Originalism doesn't always mean that the right wins and the moderate left loses. For example, Boumediene, which is a very important case several years ago about the meaning of the habeas corpus clause. This was the provision that guaranteed people at Guantanamo the ability to challenge the legality of their confinement. And the conservatives argued that the habeas clause, that the original meaning of the habeas clause didn't apply to enemy aliens locked up outside the territory of the United States. And there was this huge fight about what the original meaning of the habeas clause. I thought, apart from the fact that such important things were at stake, the actual litigation struck me as an exercise that only Monty Python would understand. Because what you had was one team saying, no, 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 look at the Scottish precedents in 1738. In 1738, a court in Scotland was asked to do a habeas, and they wouldn't do it. So the conservatives say, see, it didn't exist. Someone else says, oh, no, 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 you're looking at the wrong precedents. It's the precedents in the Isle of Man in 1654 that you want to look at. And I'm thinking to myself, this is the 21st century. We're thinking about what the meaning of the habeas corpus clauses is in the 21st century, and I'm looking at some decision in Norman law French on the Isle of Man, and that's going to decide it. That's what originalism drives you back into. In Boumediene, 5 people liked the Isle of Man better than Scotland. And so they said we have habeas corpus rights. So that it doesn't always reach the wrong result, although I think it's an absurd way of construing the Constitution. The problem is, and your fundamental question is the hard one. What does somebody like me have who rejects literalism and rejects originalism? What do I have to substitute for it? What's my philosophy of reading the Constitution? And there we are in deep water, because the philosophy that Justice Brennan used for much of his life, that he called the living Constitution, he used to call constructive originalism. And constructive originalism consisted in taking a reasonable founder, rotating that reasonable founder 200 years into the future, sitting him across from Justice Brennan, and Justice Brennan would say to the reasonable founder, what do you want it to mean? Well, you know, it's astonishing how often the reasonable founder agreed with Justice Brennan. Because that's not a philosophy. I mean, talking to ghosts in the dark of night can't be a philosophy of reading the Constitution. So the dominant Brennan philosophy really is not persuasive. And that leads us to what I think we have to do, and that's be honest and say, look, there isn't some fixed meaning coming out of the past, imposing itself on us. That's a fiction. There never was, and if there were, it would be Dred Scott, where in 1856 they did do originalism, and you know what? They said that blacks were so hated when the Constitution was adopted that they couldn't even be citizens in 1856 of any state. That's what originalism gets you. Locks you back into a world in which we had slavery, we oppressed women, and we glorified landed wealth. Who wants to read a Constitution that way? So we have to say it's an open texture document where we have to make the best guess for our times about what it means. Does that give a lot of power to judges? Yes. But it seems to me the only way that we can keep the document flexible and meaningful for our times.
So I guess given what you just said, the Constitution having such great hatred for blacks, I'm wondering if poverty is the new face of blackness, because as corporations continue to raid this country, we've got protests going on downtown. against these kinds of actions. What do you think the Equal Protection Clause, what are the revisions that you think might be needed there to prevent some of these rich getting richer, poor getting poorer? What do you think the revisions there would look like?
I'm sorry.
Under the Equal Protection Clause,
Yeah, how would you
or the 14th Amendment?
That's an interesting question, because the Equal Protection Clause has never been read to mean equal economic outcomes.
Education.
What?
I'm thinking education and every other aspect of it.
Well, there, I think equal protection has to mean equal opportunities.
Right.
And there you can read and should read educational opportunities. Courts have read that into similar state constitutions. I think you could read that into the federal constitution. How you then enforce that is another question. But I would be very happy if we could read the Constitution in such a way as to give real political power to people who are low income, and they'll make their own economic opportunities through the use of political power. But the problem we have now is that the political power is all flowing to the top and to a very few people, and the Constitution is being read to okay that. So the Equal Protection Clause and some of the other clauses can be read and should be read, I think, to broaden opportunity in a lot of different ways, without specifically talking about economics, because that's much more difficult.
Yeah. The Congressman's observation about state constitutions is an important reminder that the federal Constitution isn't the only game in town. For education, for example, there was an attempt made in 1973 to argue that equal educational opportunity was protected under the Equal Protection Clause, and we lost. That was a case I worked on. But we then took that into the state courts, and there are now 16 state courts that have passed on it. 8 of them had ruled saying you have to provide equal educational opportunity. 8 of them have rejected it. And the struggle and the battle continues. But the biggest mistake I think we made under the federal Equal Protection Clause was to forget that the purpose of the Constitution is to protect the weak against the strong, not the strong against the weak. And the day 5 members of the Supreme Court said that affirmative action was unconstitutional, what they wound up saying was that the white majority can't do anything for the black minority because it would violate the Equal Protection Clause. Why the white majority needed protection against itself is something I have never been able to understand.
I know that in recent years, a lot of people have been saying that, we're an incredibly polarized political system and everything. I'd like to ask, from firsthand experience, what do you think, A, do you think that Congress and all of our politics has become indeed more polarized? And B, what do you think the sources of that are? Is it the way campaigns are run and financed? Is it just the lifestyle that congressmen have to lead nowadays? And is there any hope for kind of reconciliation or creating a more sort of bipartisan system?
I will diagnose, but I will not. But I can't give real reasons for it. Yes, I think it's an extremely polarized system. I think that the ideological differences between the two parties. Well, first of all, historically, American political parties have been diverse coalitions because you had to get a majority. You always had Democratic members of Congress and Senate who were far more conservative than some of the liberal Republicans, and Republicans who were more liberal than some of the conservative Democrats. That's not true today. The most liberal Republican in the Congress, based on National Journal reports, is far to the right of the most conservative Democrat. There's been an ideological restructuring. The Southern Dixiecrats, the conservative Southern Democrats, are now conservative Southern Republicans. And by the same token, a lot of the people who used to be moderate Eisenhower Republicans are now Democrats, or their children are. The political parties are further apart ideologically, I would say, than in any period in American history, except for the decade of the 1790s and the decade before the Civil War. And I think a reading of American history would say that's true. I don't know how you bridge that. I'm I'm not sure exactly why that has happened. That's a political and sociological explanation. Part of it is, I would suspect, is because over the last 30 years, since the Reagan election, the country's become much more polarized. In fact, I'm sure this is a lot of it. We had a large middle class, which had a moderating and stabilizing influence in our politics. Since the early 80s, we've been destroying the middle class. We've doubled our productivity since 1980, and essentially 100% of the benefits of that have gone to the top 2% of the population. The median income is not up since the 70s. It's down or even. That gives more and more political power to a smaller and smaller group at the top, more and more economic power to a smaller and smaller group at the top, and we're going in the direction of society which is a very small top, a very large bottom, and very little in the middle. That's going to be polarizing politically and ideologically. We also have a system which is, and this is, well, it's Constitution Day, maybe we ought to talk about it. We have a system that is, in many ways, is very, very good, but in many ways is a reflection of some fundamental mistakes, in my view, made by the architects of the Constitution, who didn't expect the development of political parties, who didn't period, and who designed a system designed to prevent action. Designed to prevent action. In most democracies, a prime minister is elected. He or she has the ability to enact this program. And one of three things happens. The Tories get elected, or the Labor Party gets elected, or whoever, and either they don't do what they said they would do, and the electorate knows who to blame, or they do exactly what they said they would do, and there's peace and prosperity, the electorate knows who to reward, or the economy falls off a cliff, and the electorate knows who to blame. You unite power and responsibility. In our system, you have three different constituencies, the House, the Senate, and the President, elected at different times and by different constituencies. Even when one party has all three, which is only 8 of the last 30 years, they're differently elected. It's very difficult to get anything through. Under our current system, where you now have you have to get 60 votes in the Senate, which is an extra constitutional requirement, which I think ought to be eliminated, but that's a separate question. 40% are a blocking minority. 40% can block anything. The result is, when you have a polarized politics, nothing substantial except in an extreme emergency, like arguably the first 6 months of 2009 is going to pass. The electorate gets more and more alienated and maybe more extreme because they don't know what to do. One of the things we have to do in our politics is figure out a way of having elected majorities be able to carry out a program and be held accountable. Right now, we can't do that, and that's a real weakness.
Yeah, Congressman Nadler's description of the blocking minority in the Senate, the 40-vote Senate, which is this filibuster. It used to be that, remember Mr. Smith Goes to Washington? You had to hold the floor, and it was a heroic thing to have a filibuster. Now, you utter the magic word filibuster, and you don't really have to have the floor. So everybody turns the filibuster switch, and there's a filibuster on everything. It's a costless phenomenon. So you can't get anything through the Senate without 60 votes, but that's even worse than it sounds, because the Senate is not an equally apportioned body. Providence, Rhode Island has the same representation in the Senate as California. They each control the election of 2 senators. It is the world's most malapportioned body. And so 40 senators representing 19% of the population can block anything going through. So that creates a intensely polarized country, because the country gets angrier and angrier because nothing seems to happen. And then we make it worse in 2 ways. First, our nominating process, using primaries to nominate and allowing members only of the political party to vote in the primary, looked great in the middle of the 20th century. It looked like a great democratic reform. What's happened, and we didn't figure it, is that only the real strong partisans would come out to vote in primaries. Most primary elections, you get 10%, 20% turnout. That's all you get. So you get the extreme members of both parties voting in the primaries, and they tend to nominate the furthest out members of each party, making the election a battle between 2 very, very polarized candidates and leaving the middle essentially unrepresented. And so the Supreme Court has declared unconstitutional over and over again mechanisms that would allow the middle to participate in the nominating process and somehow make it a little easier. And the second thing is campaign finance reform. As soon as you say independents, either a corporation as an independent or very, very wealthy independent people, can spend as much money as they want pushing their pet issues in an election campaign. What you wind up doing is drive the campaign out to those issues, and the candidate loses control of the campaign because independents are setting the table, and they're setting the table at the extremes. So a combination of the nominating process and the electoral process reinforces Congressman Nadler's really brilliant diagnosis of what's wrong.
Well, thank you for that adjective, but I'm not sure I would agree. Certainly the fact that outside big money can control primaries and so forth distorts the process. I'm not sure it distorts it to extremes. I'm not sure that it goes to the extreme left or the extreme right. It goes to certain private interests and certainly against spreading the wealth. I would not support opening primaries to non-partisan, to people who are not members of the parties. I think the Supreme Court was right. And that if you want to allow, what's a political party? A political party is an association of citizens who presumably think alike, and they ought to be able to put up their candidates and limit who chooses their candidates to the people who choose to join in the first place. I see nothing wrong with that. But and I see nothing wrong if that means that the more left-wing views and the more right-wing views are going to predominate in the primaries, as long as you have a system which allows the people who get elected to actually do what they were elected to do. And then the electorate can judge the results of that and react the other way next time. What we have now is a situation where more and more right-wingers, and I wouldn't say left-wingers because we don't really have a very left-wing Democratic Party or Congress, but when more and more people get elected, but they cannot, nobody can enact their program. And the result is that the people get more and more alienated, and not apathetic, but alienated, because we didn't solve the economic problem. Why? Well, the president will say, you didn't pass my jobs program. The Senate will say, well, thank God we didn't pass your jobs program. It would have been much worse. And nothing will get done if you elect the other guys either. So you never settle the issue, and you never try it one way or the other. And that is a real problem in American politics that we must solve.
Well, thank you, gentlemen, for this wonderful And Congressman, you're personally responsible, your offices, for sending us all of our constitutions, so thank you for that and for everything you do on behalf of the university. And
thank you.
Professor, it's a real pleasure to have you here. And we'll see you all in a year. Thank you.